in a better case, not in this case.
This only technical. Not on the ground, it's not on the ground.
No, not this.
Not on that. Because I know how to do the technical. Hope it not that you want to be interviewed and correct the question. They will follow in that statement wrongly. But I am not much concerned about that now. Now you have to kindly consider the matter. 2 minutes. You have to kindly consider 2 minutes. But I am ready on the
not without a set state. The appropriate state is no, not this.
I'm not supporting the order match day. Match order is in my favor. Match order is in my favor.
In your favor, and they have successfully calculated before the High Court came. We don't find any reason.
What is wrong?
Under 136. This is not a
what is wrong in the order of High Court? I can convince you not to do it. It's the life of the medical student. Whether he is student or not, whether he is student or doing medicine, and whether he is student doing agriculture. You have come there, not even some doctors are doing, not doing present there, and this is not when there are names of the FIR. The purpose of investigation is to find out the truth. When the investigating officer examining many witnesses in the area, and the record of the statement is found that these three were not these two were not present there at all. Then that is rejected simply. Then what is the purpose of the investigation? That's what I got my own question to myself. What am I getting to see? Whenever a person goes with a false complaint, it is for a police to verify the correctness of the allegation, but to find out the truth. But he has found out the truth. But he has recorded, it is based on, it is not out of his own imagination. He has recorded the statement that many witnesses that look at all.
There are sufficient safeguards in the CRPC, Mr. Nagamoto. At the time of reading of charge,
not at the time frame of
We have appreciated in the morning your invaluable assistance. We now appreciate your tenacity, but now let us pass on this phase.
There are only one case. We will
consider it. We go on. How far is it believable that after draw the receipt, but what draw the receipt? That was sent to the party that they gave that. To take the time lag, it takes some time. You saying the figure that I wanted to draw the receipt. Visualize. You have received the button. You have to draw the receipt. Out of this game, and look at the other side, when police party takes some time to come, and by that time the police party comes, we have not done anything about drawing this. Does it not show that you had the intention to set the money not as lawful duty trade for
First of all, it is going to be my case that there is no evidence of demand here being broken. And I will show that because it is the case of the complaint that the day prior on 14th of February 2000.
And that's not correct. Not 19. Okay,
yes.
That they have filed.
Yes.
It's your seat. Greater than 30. Krishna has 30 years. Age 19.
Yes. So my lords,
So you would have argued him out. Say, yes, I did. You can't.
just
Garden and receipt is immediate.
my lords, can I just pause for a moment there? About the demand in demand in terms of legal gratification. Now, my lords, again, my lords, that is not being even tried, and only said that to the High Court and it's observed there. It has come on, and after the time when I'm thrown out of the job, it's impossible for me to satisfy. So, my lords, allow me to satisfy on 4 aspects. My first ground is, my lords, the sanction itself. Here is a clear finding also of the High Court that the sanction was completely mechanical in nature. My lords, I would also request my lords to consider one fact in mind, that this is an incident of 15 February 2000 and he's 70 years of age today. And my lords, as per the High Court, there is a minimum sentence that has been awarded. It's reduced down. He's 70 years of age. It was thrown out right at that point in time. And I'll be able to, if I can segregate 7 from 13, then my lords can take a try and see how it can be worked out. But the first thing, let me try and satisfy. My lords, just look at the additional documents. There was a draft that was given to the office, which is page number 107 to 111. And the final document that the officer approved is at 112 to 116. Now they are identical here. My lords, these are additional documents. So the first additional documents that have
Age is
yes, my lords, it is 107 to 111. So my lords will find that the draft is identical to the final, and that is so evident to the officer in his cross-examination. He says that he did not make any changes to the draft, sanction, order, and all. But my lords, he now page 72, 73. These are identical. My lords, he says, I didn't make any changes because I couldn't get everything was fixed. But this can't be in a mechanical manner. My lords, this is what is nice at the end of the day. 70. Yes, my lords, please come to page number 71 of the SL, not the page of the SL. I'm sorry. Please come to bottom of page 71. What, you did not change the wording of the draft while issuing a sanction order? I did not change the wording of the draft because I did not find it necessary. He completely admits the draft as was submitted by an officer.
What
He
is wrong
accepted
with
it.
What is wrong with it?
I submit.
What is wrong with it?
There is no application of mine.
No, that's not correct.
Yes. My lords, the High Court gives the same finding. My lords may turn to page number 10 and 11 of the High Court judgment. My lords, I'm basically on these 4 points. Allow me.
So let's first note down the points. First is sanctions mechanism.
My lords, then
Second.
second is under section 17. The investigation is to be done by an officer not less than a rank of DYS. It's an admitted position that an inspector has carried out the investigation. Before the High Court says, without any material, that the High Court says there is some government GO of Maharashtra by which even an inspector can carry out. That document is never produced, it's never taken up on record, it's nowhere on record. But section 17 of the PC Act is clear that an investigation cannot. My lords, my third is that the punch witness, now there is only one punch witness to the incident. And he admits that he's related to the complaint. And my lords, my next submission for my lords is that it is my case that there were 8 years of land revenue. And the demand has not been proved by the prosecution because it is the case of prosecution that the demand was made on 14th of February 2000. And the plan was made that he did not have that much amount on that day, and further told me to give 712 extract at that time. I gave him 712 extract. Now, my lords, this is proof because the investigating officer says when he filed the complaint, he had Xerox copy of 712 extract. That I will be able to show. He says I gave him 712 extracts on 14th itself. They further told me that he would bring the amount of land revenue of 305 if he is in need of further copies of 712. On 15/12/2000, he came to me and demanded 712 extract. I gave him the 712 extract. Thereupon, he paid me the amount. I took out the receipt book from the cupboard. I took out the said amount and kept it in the pocket of my pant. Thereafter, while I was taking out the daily receipt book from the cupboard, the people of Anti-Corruption Bureau caught me. Therefore, I did not issue a receipt. I had asked Inspector More also to see register 8B, but he did not see it. 8B is the area of land revenue register. I say the case against me is false because PW1 and 2 are in relation of each other. Now 2 is the punch witness who accompanies. Yes, my lords, there are not 2 as is normally the case. Now, may I show that part
You admitted to one on 15th of February. This is 28th of you admitted to one. Then, without money, partly certified expense. And I took a picture that he paid, wanted the extracts, to get the extracts, then the money was given.